Family law is about people, not paperwork. Trusted by thousands of UK firms, Leap's legal software gives family lawyers a single, fully integrated platform to scale your practice, stay compliant, and deliver better client outcomes. Learn more at leap.co.uk.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello and welcome along to the latest Today's Family Lawyer podcast. Today I welcome Frank Arndt onto the podcast. Frank is the founder of Paradigm Law and, for the purposes of the conversation today, the co-founder of What Would a Judge Say, a new business born out of your experiences at Paradigm. I don't think you need a huge amount of introduction, Frank. We were just talking before we started recording. You were on the red sofa at the BBC talking to Charlie State in the wake of the Radmacher case. So the Today's Family Lawyer podcast should be fairly straightforward for you. You're also pretty well known on LinkedIn for sharing your views. It's great to have you here. Thank you so much for joining.
Thank you, David. Pleasure to be there.
In the first instance, then, tell us a little bit about yourself, your background, and your journey into the family law profession, Frank.
Yeah, you possibly already hear from my accent. I'm originally from Germany, and I came over to England because I didn't know anything about the English law, which is totally different to the continent, German system, French system, or other systems. And I wanted to stay 4 weeks in England, but my former boss said, no, actually, we need people like you. I'll offer you a job. And I thought, oh my gosh, what do? I don't speak very well English. I don't know anything about the English system. What on earth am I doing here? So she said, no, I offer you a job. You're not going back to Germany, so you're staying. I have then the balance going back to Germany and doing what I do there as a qualified judge, or do I jump into the English Channel and see if I can swim or not? And that's now 23 years ago. So here I am, still enjoying the English weather, but the English system is fascinating, and that's where I really enjoy myself. Family law was always a passion. International family law is one of the big topics I love, because England is the capital of divorce, still is after the Bhutan case. And that's where I thought, okay, I give it a go for a year, and I never look back. And yeah, like you said, started my own firm, and try to give my contribution to family law, my experience, and I hope I can do that another 23 years. Who knows?
The context of the discussion today is the launch of this service, and it comes against the backdrop of a huge rise in contested financial remedy applications, the length of time that divorces now take, open criticism of costs and the legal bills that are racked up over the course of particularly these high net worth applications, but even now sort of trickling down into medium, sort of net worth individuals as well. We are seeing huge amounts of money spent on contested divorce cases. I mean, you've got your own firm, Frank, at Paradigm. Are you seeing that sort of happen in your own organization, that clients are really putting a lot of pressure on fees, and you're seeing fees rise, and that sort of contested nature of divorce is on the rise?
Yeah, we started off, when we did Paradigm, we started off with the fixed fee model. And I remember this is now 11 years ago. And I remember a lot of colleagues were saying, oh, it will never work, fixed fees. Because how do you know? How do you know how long do you work with a case? How contested will it be? And that was my background from Germany, because we have fixed fees. We have tables in Germany where we look at certain issues. And we did the same. We created a formula, we created certain multipliers, and we're looking at a case when they come to us, and look at the issues, look at the complexity. And with our experience of over 30 years, we know roughly where a case goes. We know roughly where we can can extract some really trouble or some really legal battles, and that's all put into the fixed fee. It works. I always say there's a 5% rule. You always have 5% where you don't anticipate certain things. You never know, is this a client or is the opponent all of a sudden behaving in a way you don't know, but overall it works. And then what we noticed more and more is that we have the problems with the courts, because court delays, sometimes final hearings are listed 12 months and families have to wait. And that's when we all of a sudden started, we have to do something. We have to look at alternatives, like we looked at alternative models to the hourly rate. We have to look at something which actually helps families, which helps clients. And what I came across over the last couple of years, because when you look at it, it's an old statistics, but I don't think it has changed. Over 60% of the divorces are initiated by women. And when I was speaking to women in the first initial calls we have, I always heard that they're saying, but I don't know where to start. He already has this and that. He has an accountant who helps him. He has a friend who helps him, but I don't know what my options are. And that's where the idea comes, because a lot of women said, so what would a judge actually say, and what are my options? I thought, yes, I think that should be the start, that you have not only equal footing, but you have all the information available there from the start for both sides, not only for the women, but for the husbands as well. Because what I hear always is, but he said he will do this, and he said I can do this. And then you have to say, sorry, but that's not the law. He's just saying it to push you into a settlement and. So what we noticed then is, why don't we actually look at it more deeper? And then last year in April, I think it was actually on my wife's birthday, the 29th of April, 2024, the pre-action protocol came out, where all of a sudden people were saying we have to look at ADA as an alternative. And that's when the idea was born, and said, yes, this timing is perfect. We create, I mean, there is an ADA, I always call it the ADA family. We have the private FDRs, we have the arbitration, we have the collaborative way, and we have the early neutral evaluation. And that's what basically what would a judge say is, where you put your information together. We will brief an experienced lawyer who's also sitting as a deputy judge, so you have some quality there. And we brief them to give us an opinion. And this opinion will be then discussed with the client so that they can see what's possible and what's not possible. And it's mainly a range, what is possible in certain cases. And most of the cases are needs cases. And these needs cases, when you have the range, what's possible in that particular scenario, then they can take that and say, okay, we see what's possible, we discuss it, or they say, oh, I don't like this. They can take it into the mediation and have more discussion about it. This early transparency of options, of information, and not misinformation. And that's, I think, one of the big problems here. In our time we're living at, there's so much misinformation out there, and ChatGPT is not helping at all. I think ChatGPT is actually, if you use it wrong, it can really be a danger for your case.
Sure. You've kind of given some context to why now is kind of the right time to address this need. We were chatting before, and I sense there's a soapbox coming here, Frank. But I mean, the judicial system, the family law system, is creaking, and that's probably an understatement, I think, for most family lawyers.
It is, because I think we need more money for the system. We need more judges. There is a massive backlog. We have very good judges out there which do their best, but the volume of work which comes through the door, it's not good. And I'm just going back again from my experience how it works in other jurisdictions. And when I look at the German system, you have a lot of work outside the court between the lawyers, where the lawyers have to find out what are the issues, narrow down the issues, and then they are sending their case. In family law cases in Germany, for example, they send them to judges, and the judge will look at it and say, okay, I think this case is now ready to be heard by me. And if not, the judge gives you some guidance and say, I want to hear from you, wife's lawyer, a little bit more on that topic, husband's law a little bit more on this topic. I don't understand how you plead this. And then they come in and then they settle their cases very early on. And that we have this tool with the early evaluation. I mean, it's not a new idea.
No.
It's 15 years old. When I actually looked it up, it's 15 years old. And when Matthew Thorpe, a wonderful Court of Appeal judge, was writing his paper about FDR, private FDRs, it's in there, but nobody is using it. And I thought, why is nobody using it? Why are we not putting it out there for the public to see this? This is a tool you can use there to narrow down things and not to wait a year until you see a judge.
I always, in the course of these discussions, try and keep the family lawyer in the back of my head, thinking about the kind of questions that they may well present in these discussions. And I think one of the first things that comes to mind, Frank, is that this feels like almost like turkeys voting for Christmas, because if you bring that information up front at the start of the process, then a lot of the fees that could be generated through some of that undertaking, actually start to disappear. There's a risk of that.
Yeah, no, you're absolutely right. You're spot on there, David, because I think it's actually the reason why nobody's using it for 15
Quite
years.
Possibly, yeah.
But that's not fair for the clients because it's out there, it's something there. And the interesting thing is when we started, What Would a Judge Say? It was actually a lot of solicitors which introduced their members, a sister, somebody else to us and said, we know how the system works. You don't want to pay lawyers. You don't want to fight fights which you just can't win or no judge will decide that. And that is actually, that was a very, very powerful thing where I think we have something here, but people need to know more about it because lawyers know about it, practitioners know about it, litigators know about it, how expensive it is, how risky it is, and how stressful it is as well. Because we have to remember when you look at a family law case, and I had a fantastic mentor in Germany, my family judge there, he always said, Frank, look at there is a family behind it, there are children behind it. The children don't want their parents to fight about certain things. So you always have to look at the people which are not in the room when you have the first initial call with somebody, because these are the most important people and you influence their life as well. So that's always on my mind when I'm looking at cases. I always look at the family and the wider family and the future for this family.
It's very in vogue to talk about unbundled legal services, and it's one of the sort of buzzwords that the regulators have been talking about for the past couple of years. This feels like an example of unbundling legal services. Frank, do you take that point, or do you feel differently?
Yeah, unbundling is something I think we will see more, definitely, because when you look at Professor Suskin's book there, it's one of the topics there. The unbundling, when you think about it, comes exactly from the education of lay clients because they know more what they want. And I think we as law firms, as lawyers, we have to not only accept that, we have to obviously show them also what's possible. ChatGPT helps there as well. I sometimes see that ChatGPT is unfortunately used in the wrong way, in the wrong prompting way. But I think we can't close the door. I think we can't not use AI. I mean, there was just yesterday a case out there. It was a children case where the Court of Appeal said, yes, I think we all know how to use it. We have more and more litigant persons in court. I think the percentage I saw was 26%, and that's an old 2-year-old data. So when we look at that, we will have more litigant in person because they can't afford lawyers. They use more ChatGPT. But it's a question of how do you use it responsible? How do you use it in a way that is useful? And also you need to own it. You need to say, I used for this part ChatGPT. You can't just, we have all seen the terrible cases where barristers and solicitors made up case law, which didn't exist.
It starts to hallucinate, doesn't it?
Absolutely. But hallucination is there. I think it's getting more sophisticated, but we always, and that's what we do on What Would a Judge Say as well, we all have an experienced lawyer, a human being, looking over the shoulder of a ChatGPT or an AI. And that's, I think, quite important, because if you use it in the right way, it can be very powerful, it can be very helpful, and it can be also make you think about things you haven't thought of. There's a wonderful professor in Graz, a law professor. She encouraged the law students to use AI, but obviously put it in the footnote and say this is AI related, because she said I use it as a kind of brainstorming. If I have a problem, I ask ChatGPT or whatever you want to use there, and ChatGPT comes with 4 or 5 ideas I have as well, but the one I might overlooked or haven't considered. Yeah. So it can be powerful, it can be useful. It's a good thing. It's a bit like, I mean, old enough to remember when Google started, when the internet started. It was exactly the same. So yeah, I'm not afraid of it, but you have to use it in a respectful way, in a human way as well. We're talking family law. This is not contract law. So you have to take all the ethical steps there as well, and you have to, as a lawyer, be responsible.
There's a lot of talk about AI taking the jobs of lawyers, and my sort of view on this, and I've expressed it in the course of this podcast previously, is that I don't believe that AI will take the role of the lawyer. But what I do firmly believe is that the AI-enabled lawyer, i.e. the lawyer that is capable of using it effectively, respectfully, to the points that you've made, Frank, better than a lawyer that can't, that lawyer is going to be much more employable. That is the lawyer of the future, rather than any risk of AI taking our jobs.
I agree with you. I don't think AI will take the lawyer jobs. I don't think that's possible, because the lawyers have, and I come across as very, very great lawyers that have experience. You can't just ignore that, and AI can't catch up with that. It will one day, but we're not there. But I think the way we're working and the way we're looking at certain strategies, volumes of documents, looking at it is changing. And I think what we will see in the future, you have more a team working together. We'll call it the digital team, where you have a lawyer who is interested in AI but has the experience, and then you have a data analyst working together to get the best for the client, to prepare the best strategy for the client, to use all the tools available. If you go back when Google started, why wouldn't you use Google? But what do you get from Google? You just get the first layer of information, and then you have to dig deep and you have to analyze it. You have to make sure you're not using faked information. That becomes more and more a topic in the future. And there was yesterday, there was an interesting case also about ChatGPT and prompting, where actually a judge was confronted, and this judge said in the children, okay, this is all new for me. I've never heard about prompting and ChatGPT, but we will see this more in published judgment, where in that case the father had access to the mother's ChatGPT and used the prompting history to make a case against the mother. And what I found there quite interesting is that the judge said, but you have to look at prompting history in a context. That's, I think, where we're going when we have actually lawyers, when we have data analysts, when we have AI tools. You have to look at it and put it in the context, back to the family, back to the circumstances this family find herself in, whatever that is at that stage. And you can't just isolate things. And that's the danger when you just use ChatGPT and you are in a bit of an echo chamber as well, because there is this AI bias there where you feed obviously your ChatGPT, and the ChatGPT is telling you stuff you want to hear. But where is then the complex resourcing? But what about this? And what about that? Have you thought about this? And that's where lawyers coming in and saying, we need to look at it in a more context-driven way.
To throw this back at you a little bit then, Frank, you've identified you already use experienced barristers, district judges to support the early neutral evaluation advice that you're providing. At some point in the future, there's an opportunity for AI to take on some of those roles and responsibilities, because we can feed an AI engine with all of these decisions and nuance and that kind of thing. What risks does that pose, do you think, to the future of law? And do you see that we can rely on AI, or will it still remain, driven by lawyers? How do you sort of see that dynamic working?
I always use the example, obviously, as a German person, we love our sausages in Germany. It's always about what you put into a sausage, you get out. That's the quality. And I think it's the same with an AI judge as well. What information you put in, what learning experience this AI has, that's the quality you get out. And I don't think we are there. And I don't think we will be there very soon, that we can replace a judge. That's impossible. Like I said, this is the experience, the daily experience. AIs they learn very fast, and I'm sometimes surprised how fast they learn. But this human context is missing with the AI, and you can see that. And we have a tool, an AI agent called Menlo, where we are training Menlo. And you can see there is a certain bias with Menlo. Why that is, it's just the learning process is in a different way. And I think that's where a judge is stepping back and has the experience and put the experience into a judgment as well, as a human being. And I don't think we can replace that.
But what about the role that technology plays in taking the client through that journey, that emotional journey of divorce, for the sake of argument? We've talked about unbundling services, and unbundling is there from a cost point of view as well. We recognize that this is an expensive process. What kind of role do you see that technology and the lawyer play in taking that client through that journey?
I think with when I look at cases, the cases just don't start and then next day you have a decision. Cases are developing, like a relationship, a marriage, partnership develops. The connection with your children, they develop as well. So this is a longer process. And if it's a longer process, that means we get a volume of data. That's, I think, where the journey is, where we guide people. And what comes along, we have a lot of parental alienation cases coming up, coercive control cases. And it's about the information, the evidence. We have to look at it in the first initial meetings and looking at the evidence, using the evidence, and isolating the evidence which is not relevant or which you can't just use or would counterproductive and. So that's where you are looking at it. And the journey is a longer journey. And you always have to step back. What's there? What's the latest development? And so I think we are the unbundling is one side, but AI can help us to also remember what was actually last year in this letter I wrote to that lawyer. What is the change in the dynamic right now? Because something happened with this family. Something happens if it's a finance case. Something happens, I don't know, with the housing market. The valuation of the houses went down. Something happens with the inflation. And the letter I wrote 12 months ago is not relevant. What actually did I write there? So it's this memory we will have there, this brain memory, I will call it in converted commas, which is there with the AI as well. And that guides clients, that guides the team, the lawyer and the data analyst, to actually adapt all the time and being flexible to get the maximum for your client, to get the best result. And when I say best result, means also finding the compromise in a dispute, in a family law dispute, quicker, and trying to argue your case from the other side as well, so that you can see what is actually here the best way forward. And sometimes the compromise is the best way forward.
We are fast moving towards the end of the time we have for the conversation. And I sense that we're really only scratching the surface of some of the ills of the family law process, Frank. But just to kind of end the discussion, it's one of a number of solutions that will undoubtedly come to market over the course of the next 12, 18 months. Can you kind of share what sort of feedback you've had in terms of people that have used it, have sort of informed how you develop the service further?
It's very interesting because we had a surprising feedback from the Cayman Islands. There was a lawyer who said, I want to hear more about it because I want to introduce this into the Cayman Island jurisdiction. And we talked about it. This particular lawyer said this is a fantastic idea to have actually these opinion there. We had a lot of clients, you can't call them clients because they came to us and said, why didn't I hear about you 12 months ago? I needed you 12 months ago for this information. And clients which go through the process are exactly happy with A, the transparency, B, with the speed, that's quite important. And they use this legal opinion and they say, I hope more people know about it because it's out there 15 years. And nobody is talking about it. Why? Yeah. So that's the feedback. And the future is we want to, like I said, the Cayman Island is one thing. We want to look at other jurisdiction. We're looking at Scotland at the moment. They have a similar backlog. So we look at other jurisdiction where it's a similar problem. And if we can assist parties, couples to make the decision earlier, to start their life earlier, because when you look at it, 12 to 18 months until you have actually the opportunity to see a judge. What can you do in 12 to 18 months? Yeah, you waste your time for that. When not only cost, it's time, and we all need this time to spend this time with our children. We see our kids growing up while we're going through the court process. Why?
I really liked what you said towards the start of the discussion, which was that as lawyers, we have a role to play in educating our clients. We know that there is this drive towards greater transparency. I think things like this have got application beyond this jurisdiction, to your point, because of course what we're doing is we're just trying to do disclosure, but at an earlier stage in the process,
exactly.
I suppose. And interestingly, listeners to today's Family Lawyer podcast may be aware that we have a wills and probate publication, we have a conveyancing publication, and particularly in property law at the moment, there is a real drive towards creating greater transparency in a property transaction, because what you see there is 1 in 3 properties fall through because something comes out of the woodwork, 8-10 weeks into the course of the legal process.
Yeah.
So anything that we can do, and I'm on board with this culturally, but anything we can do to bring more information out at an earlier stage to enable more informed and better decisions can only be a good thing. So Frank, enormously grateful for you joining the podcast, sharing your insight. Thank you so much.
You're welcome, David.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Frank. Thank you as ever for listening, and we'll see you again soon.